So again, welcome back to the Civics Project for our February 21st session on the federal courts. I'm Beth Ribet, the Director of Repair and the host of the Civics Project. I'd like to begin with a land acknowledgement. Repair acknowledges the Tongva peoples as the traditional land caretakers of Tovangar, the Los Angeles Basin and South Channel Islands. And we're grateful to have the opportunity to work for the Tarahatom, the indigenous peoples in this place. We pay our respects to Hanukvatam, the ancestors, Ahihiram, elders, and Eohinkam, our relatives and relations, past, present, and emerging. So today's conversation focuses on the federal courts, also known as the judicial branch of the U.S. government. The term judicial has a common root with the word judge. So in other words, the branch of the government responsible for judging questions related to a broad range of areas in U.S. law. The federal court system in the United States has multiple levels or tiers. The lowest tier are the district courts, and there are currently 94 of them in the United States. So district courts, federal district courts, are scattered geographically all over the United States, and they hear basically the first claim that comes into a federal court in the United States. There are also 12 regional appellate, or also known as circuit courts, and these are the courts that hear, with a 3-person panel, generally, appeals to cases that have come into the district courts. So when you are a party to a case in a federal district court, you have a right to at least one appeal, and those appeals are heard by the federal courts of appeals, also known as the appellate courts or the circuit courts. And again, there are 12 regional courts, and if you hear someone refer to 13 circuit courts, the 13th is known as a special court of appeals for the federal circuit, and it deals with some very specific claims that apply under federal law. In addition, there is one Supreme Court, and then there are also some distinct military and veteran courts that are outside the regular federal circuit structure. And of course, there are immigration courts and some specific courts for other purposes. But most cases that come up on U.S. federal law are going to be heard in a federal circuit court, and this structure is present through the United States and all its territories, including Puerto Rico, Guam, the Northern Mariana Islands, the U.S. Virgin Islands, and American Samoa. And the circuits are roughly regional, but where we get outside of the continental United States, you'll see the circuit courts, or the circuits contain territories that are not joined by any body of land. For instance, the 9th Circuit in the United States includes California, Arizona, Montana, Idaho, Oregon, and Washington, but it also includes Alaska and Hawaii, and it includes Guam and Northern Mariana Islands. And Puerto Rico, you'll see grouped into the 2nd Circuit with New York, for instance. So these are basically regional ways of breaking up the United States into different areas. So we've got this whole structure. What do the courts actually do? What is the work of the federal courts? So law in the United States is broken up into 2 categories, generally: common law and statutory law. And statutory law involves laws that are passed by legislatures, whether they are federal or state, or sometimes municipal bodies like city or county boards or councils. But we also have in the United States what's known as the common law, and the common law system is inherited from British colonialism. So this system was present in the UK before it was imported into what eventually became the United States. Common law basically says that law is also made by the body of decisions made by judges, and those decisions are known as judicial opinions. So judicial opinions, all taken together, make up what are known as the common law, and they may contain rules, norms, various kinds of precedents that are not present anywhere in the law written down by legislatures. So again, we refer to this as the common law. So what is the work of the federal courts exactly? To create the common law, and to do so by interpreting and enforcing both prior precedents, by making new ones, and by enforcing statutory laws on the books. And then this also includes the U.S. Constitution. So the enforcement and interpretation of law are both part of the court's work, both part of what makes up the common law. So what kinds of cases actually show up in the federal courts? What do they have jurisdiction over? Jurisdiction refers to whether you have a right to hear something. And what goes into a federal court as opposed to a state or local county or city courts? So in essence, the federal courts have jurisdiction over anything arising under federal law, and then they also have jurisdiction over anything in which there's, a contested question of which state court it could go to, whether because it's a claim that covers multiple states or because it involves parties who are not in the same state. These could all get a case moved over into federal court. So the federal courts, in essence, have jurisdiction over anything that doesn't fit neatly anywhere else and anything that comes up under federal law, including the U.S. Constitution. If a case is purely state or municipal, then usually it would go into a state or a municipal court. So the next question we want to think about is, what powers do the federal courts have? What can they actually do? And we have federal courts hearing both criminal and civil cases. And in criminal courts, the courts have the power to sentence people or to preside over a jury that does sentencing. So that may be the direct work of a judge, or a judge may be managing the process in which there's a jury. And in civil courts, the courts have the ability to make awards and also to order things. So we usually talk about that as injunctive relief, a court injunction, ordering a party in a case to do something. So there can be money, but there can also be various kinds of court orders. And again, the fundamental work of the court is to interpret the law and apply them to the facts in a particular case. And many laws created by legislatures are written in broad or general terms. So there can be a lot of interpretive work for the federal courts to do, and state and municipal courts, in making sense of how to apply written laws to particular cases or claims. And that's part of what keeps lawyers and judges busy, is sort of arguing over the interpretation of a set of facts relative to a particular body of law, or what's called legal doctrine. So that's a little bit about what the courts are and what they can do, what powers they have. So let's think a little bit about the hierarchy and structure of the courts, and exactly what is the Supreme Court in the federal court system. Why is it important? What does it have jurisdiction over? So as I mentioned, we have 94 federal district courts in the United States. And each of those courts is the first point of entry for almost all, not quite all, but almost all cases that arise under federal law or that make their way into a federal court. So a federal district court will hear both criminal and civil cases, anything under any area of federal law, and there's a lot of it, so those courts are kept pretty busy. And then when one of the parties appeals a district court decision, then it goes to one of those 12 regional circuits, or the circuit courts of appeals. Now, there's no right after an appellate court ruling, after a decision in the Court of Appeals, to necessarily have another appeal. But parties in a case can ask for their case to also be reviewed. They can appeal to the Supreme Court. So if you lose at the appellate court level, at the circuit court level, then you can file an appeal to the Supreme Court. And unlike the circuit courts, which have to hear every appeal, the Supreme Court can decide from all of the appeals that come in from all over the country between the 12 regional circuits and anything arising in that 13th federal circuit, which cases they're going to decide to hear. So they're only going to hear a small percentage of all of the cases that are appealed to the Supreme Court. And the structure of the courts, right, goes Supreme over the appellate or circuit courts, and then the circuit courts are over the district courts that are within their regional circuit. And an important term to know is the concept of law being binding. So we have a rule in our federal court system that when the Supreme Court decides something, that decision is what's called binding over all of the circuit courts and the district courts. That means that the lower courts are not allowed to decide a case in a way that would overrule or contradict the Supreme Court decision. If there are differences between facts of cases, they may try to argue or find a way around it. But the Supreme Court decisions become basically the law of the federal courts, the supreme law of the federal courts, until a Supreme Court decision is either overruled by a future Supreme Court, so the Supreme Court can overrule its prior decisions, or in some instances, Congress can legislate its way around the Supreme Court. But if the case arises under the U.S. Constitution, then Congress cannot change the U.S. Constitution except by a constitutional amendment, which we've talked about before and which is quite difficult to do, has been done in a limited number of times in U.S. history, and is difficult in part because it requires a lot of process and requires ratification, requires approval by 3/4 of the state legislatures ultimately in order to change. So unless we go through the process of a constitutional amendment, one of the reasons the federal courts are so powerful is they are the entity within the U.S. government that has the right to interpret the Constitution, to decide how it should be applied. And when there are contradictory decisions coming in from the lower courts interpreting the Constitution, then the final rule on that question will go to the Supreme Court. So the Supreme Court ultimately decides what the Constitution means, and there's no way around that other than a constitutional amendment. Now, if the Supreme Court makes a decision about what the federal law passed by Congress means, Congress can work around that by amending the law. So an example of this would be the Americans with Disabilities Act. The Americans with Disabilities Act, or ADA, was passed in 1990. And it was meant to basically create a broad civil rights platform for people with disabilities in the United States. And one of the things that we saw happen is that after the ADA was passed and signed into law in 1990 by the president with bipartisan support, that the federal courts started to restrict the meaning and application of the Americans with Disabilities Act. So, for instance, we had federal court decisions that came in that said, well, if a disability can be managed with medication or with assistive equipment or devices, then it won't be covered by the law in some instances. If a disability is not constant, if it happens sometimes but it's intermittent, like having a flare-up of a chronic physical or mental illness, then that might not be covered by the law. And so those are some examples, but we saw the federal courts decide that the definition of disability that would be protected under the ADA would be increasingly restricted. So one of the consequences of that is that the ADA was often not usable by plaintiffs, by people with disabilities who wanted to sue someone in federal court to enforce the Americans with Disabilities Act. And so eventually in 2008, the U.S. Congress, after lots of lobbying and pressure from disability rights communities and movements, passed the Americans with Disabilities and Amendments Act. And they explicitly cited Supreme Court cases in that Amendments Act and then said these cases were decided wrongly, and this is what we mean the law to say. And so in that way, they were basically able to overrule the federal courts, including in some instances the Supreme Court, by changing the federal law. But again, when it's the Constitution, that's very hard to do. So you can imagine that in deciding what the laws actually mean, applied to specific scenarios and instances in cases, the federal courts are very powerful. And because any case that the Supreme Court decides is binding on all the lower courts, it is very powerful as well. So let's talk a little bit about our current Supreme Court. We have 9 justices. They get paid for the 8 associate justices. They get paid currently $265,600 a year. And the Chief Justice, John Roberts, gets $277,700 a year. So he gets an extra $12,100 because he's the Chief Justice. And let's talk about who they are. So we've got Chief Justice John Roberts, and he was appointed and took his seat in 2005. His nomination came through President George W. Bush, and he's currently 66 years old. And he's generally known as a fairly right-wing justice, though maybe slightly less right-wing than some of the others, like Clarence Thomas. Samuel Alito was also appointed by George W. Bush in 2006, a year later, and he's currently 70. Stephen Breyer is currently the eldest of the Supreme Court justices at age 82 since the death of Ruth Bader Ginsburg, and he was appointed by Bill Clinton in 1994. Clarence Thomas has sat on the bench the longest of any of the current justices. He was appointed by the George Bush Sr., George H.W. Bush, in 1991, and is presently 72 years old. Sonia Sotomayor, the first Latina on the Supreme Court justice, was appointed by Barack Obama in 2009 and is currently 66 years old. And she was followed by Elena Kagan, also an Obama appointee in 2010 at the age of 60. And then we have 3 justices that have been appointed in the last presidency by Donald Trump. The first is Neil Gorsuch, and he was appointed by Trump in 2017 at the age of 53. And his appointment was particularly controversial because the seat that he was filling had come open during Barack Obama's presidency early in 2016 or earlier, and the at that time Republican-controlled Senate refused to hold a hearing about the nomination of Merrick Garland to be the new Supreme Court justice, saying they were simply going to delay confirming a Supreme Court justice until the election and then wait in case a Republican won, which Donald Trump did, and have him choose a new Supreme Court justice instead. So they refused to have a hearing on the nomination of Merrick Garland to take that Supreme Court seat. And they succeeded in doing so with a majority in the Senate. And therefore, Merrick Garland never had his Supreme Court confirmation hearing, and instead Trump nominated Neil Gorsuch, who then was confirmed in 2017. So following Gorsuch, we had Brett Kavanaugh, also appointed under some controversy, as many of you remember well, in 2018 due to allegations of sexual assault that were raised during his confirmation hearings and during his prior FBI investigation. So though his appointment was quite controversial, he was also appointed in fall of 2018, and he is currently 56 years old. And last, Amy Coney Barrett was just confirmed by Donald Trump in 2020 and is 49. And as you know, her appointment was controversial as well because she replaced Ruth Bader Ginsburg, who died very shortly before the 2020 elections, and the Republican-controlled Senate reversed their position. So they had refused to hear have a hearing about the nomination of Merrick Garland, saying they needed to wait until after the election to confirm a new Supreme Court justice, but then insisted that they could not wait for the election to confirm a new justice and instead, really rush through very quickly the confirmation of Amy Coney Barrett. So the consequence of that is that there's a lot of controversy about the current status of the Supreme Court. We have 6 judges ranging from very, very right-wing to quite right-wing. And then we have 3 who are considered progressive or liberal. And the progressives or liberal justices are generally considered to be Stephen Breyer, Sonia Sotomayor, and Elena Kagan. And the right-wing justices are the new Trump appointees, Gorsuch, Kavanaugh, and Coney Barrett, and from the 2 Bush eras, Chief Justice Roberts, Justice Alito, and Justice Thomas. So to have a better sense of who these 9 people are, and I want to spend a little time on that before we move on today, I want to just review one majority opinion that each of the 9 justices wrote. I'm just going to do that briefly, but just to give us a sense of what role they're playing in the bench. So majority opinions are written by one of the judges, one of the Supreme Court justices who is in the majority on any given vote, on any given case the Supreme Court reads. So if there are 5 justices ruling a certain way, they choose one of those 5 to write the opinion that reflects their collective decision. And then the judges can also file what are called concurrences, which is where they agree but want to add something for the record. Doesn't change the outcome, but it becomes an important part of the historical record. And they can also write what are called dissents. So judges who disagree with the vote, who voted the other way, can explain why they believe that the majority of the court decided wrongly. So Justice Ruth Bader Ginsburg was particularly famous for writing dissents that people really love to read. There'd always be a lot of, news and social media buzz about it anytime that she wrote up a decision or particularly wrote up a dissent. So the majority opinions, however, reflect the will of the majority of the court, and the person chosen to write it is, I'm sure, partly an internal process of distributing workload, but also reflects the person who is very in sync, one of the people who's very in sync with this decision and is therefore seen as best able to articulate it. So one of the majority opinions written by Chief Justice John Roberts, who again was appointed by George W. Bush in 2005, was Parents Involved in Community Schools versus Seattle District Number 1. And this decision was made a couple years after his appointment in 2007. And what Justice Roberts and he was joined by Justices Alito, Thomas, Kennedy, and Scalia found was that school efforts to engage in racial desegregation in Seattle were unconstitutional under the Equal Protection Clause of the 14th Amendment. The court basically took a position that by recognizing race, they were engaging in racism. And they were opposed in this decision by Justices Ruth Bader Ginsburg, Stephen Breyer, and retired Justices Souter and Stevens. Justice Clarence Thomas wrote the majority opinion in 2006 in Kansas versus Marsh. This case upheld that the death penalty is consistent with the 8th Amendment. So the death penalty is not cruel and unusual punishment under the Constitution. And he was joined by Justices Alito, retired Justices Scalia and Kennedy, and by Chief Justice Roberts, and opposed again by Ginsburg, Breyer, Souter, and Stevens. Our newest justice, Amy Coney Barrett, has written one judicial opinion, which was just released this month, since she's so new to the court. And that decision was South Bay United Pentecostal Church versus Newsom. And again, that was decided in February of 2021. The case arose in California originally, and the South Bay United Pentecostal Church was suing the state of California to overturn a state order closing in-person services and singing unmasked. And they wanted to overrule state pandemic safety orders, arguing that they were interfering with religious freedom or engaging in religious discrimination. So the court agreed with the church, although there were differences between the conservative judges about how far they should take it, meaning should people be able to do anything they wanted in gathering in person, or should they be allowed to gather in person but not to sing unmasked? And ultimately the decision was that they would overrule the state of California but would not allow people to sing unmasked, which tends to introduce more droplets into the air, which then might be infectious. So Amy Coney Barrett authored that majority opinion overruling the state of California's pandemic safety orders as a matter of religious freedom. Justice Stephen Breyer authored the majority opinion in Stenberg versus Carhart, which found that a Nebraska law restricting access to abortion was unconstitutional because it interfered too heavily with women's rights to make reproductive decisions, and that's still considered one of the major abortion decisions made by the Supreme Court since Roe versus Wade. Justice Sotomayor decided wrote the majority opinion in Brumfield versus Kane in 2015, which protects the rights of persons with intellectual disabilities. So a person with diminished capacity from the death penalty under the Eighth Amendment, and this arose under a Louisiana case addressing the question of whether a person with an intellectual disability can be executed by the state. And Sotomayor and the majority said that people with intellectual disabilities must be protected by the Eighth Amendment and affirmed that principle. Justice Samuel Alito decided Burwell versus Hobby Lobby in 2014, which allows corporations to deny no-cost contraception and health plan coverage, which would usually be covered by health plans otherwise, as an exercise of the corporation owner's religious freedom. So basically saying you can take things out of a company health plan if it violates your religious beliefs. Elena Kagan has not authored that many majority opinions, in part because she hasn't been in the majority as much. But in 2015, she authored the majority opinion in Kimball versus Marvel Entertainment, and it's been described in the press as one of the most whimsical opinions in the court, and even included references to, and I believe, a quotation from a Spider-Man comic book. And this was a case arising in which one of the parties was Marvel, so it wasn't irrelevant, but was definitely considered rather humorous. And the case involved basically whether a patent holder can receive royalties after a patent expires, and the majority ruled that they cannot, and Kagan authored that opinion. Justice Brett Kavanaugh has authored the majority opinion in McKinney versus Arizona in 2019, which goes against more strict and rigorous consideration of post-traumatic stress disorder and diminished capacity in determining whether a death penalty sentence is unconstitutional. So Kavanaugh and the majority essentially felt that there was a lower standard or less strict need for consideration of whether a person who is been convicted and sentenced to the death penalty or is facing sentence should have the presence of post-traumatic stress disorder or diminished capacity, meaning diminished mental capacity, be considered in their sentencing. And Kavanaugh said basically in favor of less consideration of those things, and was joined by the majority. Neil Gorsuch, last but not least, has been an interesting justice because though the majority of his rulings have been quite right-wing, he's broken ranks occasionally and voted with the progressives or liberals in the Supreme Court. And he did so in the Supreme Court case Bostock versus Clayton Count, which was the recent 2020 ruling that basically said discriminating against employees who are transgender or LG or B, lesbian, gay, or bisexual, sexual orientation or gender identity-based discrimination in employment is prohibited by the Civil Rights Act of 1964. So Gorsuch again wrote the majority opinion in Bostock versus Clayton Count, which is considered to be a landmark case for LGBT rights. So again, this just gives us a little bit of a tiny bit of a snapshot of what each of the justices has been doing of late, and some places to go to learn more about the justices and their behaviors include the blog of the Supreme Court of the United States, SCOTUS blog, and there's also OYEZ, O-Y-E-Z, which contains biographies and lots of information. And if you're looking for information as a layperson on individual court cases, you can look to resources on the web like FindLaw, F-I-N-D-L-A-W, which also will allow you to read and learn more about cases. So our book recommendation for today is an edited collection by Toni Morrison, and the title of it is Racing Justice, Engendering Power, Essays on Anita Hill, Clarence Thomas, and the Social Construction of Reality. And this was a collection that came out after the Hill-Thomas hearings. For those of you who are younger, you may not be familiar. Some of them may remember them well from the 90s. And they were certainly invoked again in popular culture and in the press during the Kavanaugh hearings, during Brett Kavanaugh's Supreme Court Justice Brett Kavanaugh's hearings for Senate confirmation, because like Clarence Thomas, he was accused of engaging in sexually aggressive behavior. So again, I recommend Toni Morrison's collection, Racing Justice, Engendering Power, Essays on Anita Hill, Clarence Thomas, and the Construction of Social Reality. And for those of you who are familiar, you know that each week we have 3 trivia questions, our civics trivia. And so I'm going to screen share with our Zoom audience and also read that for our podcast audience now. And our first question is, when the Supreme Court was first convened in the United States, how many justices were appointed to the court? And if you know or you have a good guess, Zoom audience, you're welcome to put your answers in the chat. Answer choice A is 3. Answer choice B is 4. Answer choice C is 6. Answer choice D is 7. So when the Supreme Court first convened in the U.S., how many justices were appointed to the court? And the correct answer is C. There were 6. So the norm or convention that there needed to be an odd number of justices in order to break a tie came later. When the court first convened in the late 18th century, there were 6 Supreme Court justices confirmed by the U.S. Senate. Second question, another numbers one. How many district court judgeships do we have right now in the U.S. federal court system? So how many seats are there for those district judges in the 94 courts, district courts? Answer choice A is 310, B is 678, C is 1,102, and D is 2,098. So in total, how many district court judgeships are there in the U.S. federal court system? And the correct answer is B. We have 678 seats for district court judges. This is the entry level. We have about another 179 plus some retirees in the appellate level. And then, as you know, 9 in the Supreme Court. So in total, we have less than 1,000 people who are basically making decisions about the interpretation of federal law for the 330 million people in the United States. So again, that is quite a prestigious position and a lot of power wielded by the federal courts. Last question. Can a case involving a state constitution be tried in a federal court? So if a state involves a state constitution, is it always tried in a state court? So A is no, never. B, is no, unless the case involves a conflict between the state constitution and the federal constitution. C is yes, cases involving state constitutions are always heard in federal courts. Or D, yes, cases involving both federal and state law or laws or parties from more than one state can be tried in federal court. And this relates back to my earlier lecture about who has jurisdiction. And the right answer on this one is D. If a case involves federal law or the parties are from more than one state and want to take it to a federal court, or the case involves more than one state, then the state can be tried in federal court. So usually a case involving a state constitution will start off in a state court, but if it is being contested or if an issue is being raised that also deals with federal law, or that deals with parties outside a state, or that deals with more than one state, then a state constitutional case could go to a federal court. So one of the things that means is that the federal courts can even have some influence over state law. So some more resources for our Zoom audience. And I'll be sure to put those in the chat. And for those listening by podcast, I want to thank you for joining us today. We'll be back next weekend to talk about impeachment. And then we'll be back in March to talk about the Electoral College, the federal budget, and then we have a special guest on March 21st, Professor Hiroshi Motomura, who will be joining us to talk about citizenship. In addition, this coming week on February 24th of 2021, we will have our film screening, which we do monthly on the last Wednesday as part of the Civics Project, of Suppressed 2020, The Fight to Vote, which looks at voter suppression in Georgia. So I hope some of you will join us for that as well, and you can find more information on our events registration page, which I will also share with our Zoom audience in the chat, and for our podcast audience, you can find it in the event description. All right, so again, I want to thank our podcast audience for listening in today, and we'll stop recording now and hope you'll join us again. And for our Zoom audience,